Thank you. My name is Paul Mozina. I live on Roker Street, and I would like to address your attention to the right-of-way ordinance that you're currently contemplating for the small cell deployment. And I want to point out that the definition of small cell facilities in the ordinance includes that facilities do not result in human exposure to radio frequency in excess of the applicable safety standards specified in the 1996 Telecommunications Act. So the definition insists that these facilities not pose a danger to humans. And in the whereas clauses that we saw on May 2nd that were included with the proposed ordinance, one of the phrases was, while enabling the city to promote the management of the rights of way in the overall interests of the public health, safety, and welfare. So clearly we have a mandate to consider the safety implications of the deployment of this technology. The right-of-way ordinance, as you're considering it, is predicated on the Portland versus FCC decision that was decided on August 12th, 2020. It led to the League of Oregon Cities coming up with the model ordinance and the model design requirements. But the city attorney has failed to include in your consideration that subsequent to that August 12th, 2020 decision was the August 13th, 2021 decision where the FCC it was the Children's Health Defense and Environmental Trust. Their case was heard in the Court of Appeals for the District of Columbia. A petition, it was for the review of an order of the Federal Communications Commission terminating a notice of inquiry regarding the adequacy of the Commission's guidelines for exposure to radio frequency radiation. So the lawsuit called into question whether the FCC's current measurements and safety guidelines that are referred to in the right-of-way ordinance definition for small cell, those safety standards, whether they were appropriate. And although it was heard in the D.C. Circuit Court, the same case was also brought by the Children's Health Defense in the Ninth Circuit, and the courts decided to consolidate the Ninth Circuit case with the D.C. case, and the cases were heard in the D.C. court. So the ruling of the D.C. court is a Ninth Circuit ruling as much as it is a D.C. court ruling. The cases were consolidated and brought together. And let me just read some of the important statements that the judges concluded. They agreed with the plaintiffs that the FCC needed to review its standards, and they disagreed with a few things, but overall they agreed with them. And I would like to read a few of the statements that the judge that were included in the decision. When an agency in the Commission's position is confronted with evidence that its current regulations are inadequate or the factual premises underlying its prior judgment have eroded, it must offer more to justify its decisions to retain its regulations than mere conclusory statements. Under this highly deferential standard of review, we find the Commission's order arbitrary and capricious. They're referring to the fact that the Commission said, we don't need to look at our rules. That was what was being appealed by the Children's Health Defense and Environmental Trust. They said, you need to look at those rules. And the Commission said, oh, no, everything's good. We're all good to go. But the court said, we find the Commission's order arbitrary and capricious in its failure to respond to the record evidence that exposure to RF radiation at levels below the Commission's current limits may cause negative health effects unrelated to cancer. They go on to say, that failure undermines the Commission's conclusions regarding the adequacy of its testing procedures, particularly as they relate to children, and its conclusions regarding implications of long-term exposure to RF radiation, exposure to RF pulsation or modulation, and the implications of technological developments that have occurred since 1996, all of which depend on the premise that exposure to RF radiation at levels below its current limits causes no negative health effects. Accordingly, we find those conclusions arbitrary and capricious as well. Finally, we find the Commission's order arbitrary and capricious in its complete failure to respond to comments regarding concerning environmental harm caused by RF radiation. The factual premise, the non-existence of non-thermal biological effects underlying the current RF guidelines may no longer be accurate. And so we have this assumption of safety that we cannot rely on. And I'm asking you to put a moratorium on any future right-of-way small-cell deployments until the FCC responds to the court order to revisit their safety guidelines. And I would like that ordinance should take precedence over the ordinance that's currently being considered. I really appreciate your time.
Thank you.